$7.25 billion. That is what Bayer has agreed to pay in the largest agricultural settlement in American history for farmers, landscapers, and gardeners exposed to Roundup weed killer. Internal documents suggest Monsanto knew glyphosate posed a cancer risk and buried the research. Now, a looming Supreme Court decision could shut the door on future lawsuits entirely, which means the window to claim your share may be closing far faster than you think. On March 9, 2026, a federal court in St. Louis received the formal filing. $7.25 billion has been set aside for people harmed by Roundup and other glyphosate weed killers. This is not just the largest agricultural settlement in United States history. It is one of the largest product liability funds ever created. If approved, the trust will distribute payments over a period lasting as long as 21 years, with most claims expected to be paid out in the first decade. The money is earmarked for farmers, landscapers, municipal workers, home gardeners, and families who can document their exposure or loss. The settlement's sheer size reflects the scale of the crisis. Tens of thousands of lawsuits, a decade of scientific warnings, and a mounting toll of non-Hodgkin lymphoma cases linked to glyphosate. For many, this fund represents the first real chance at compensation after years of litigation and denied responsibility. But the clock is already ticking. Deadlines and eligibility rules will determine who actually receives a share of this historic payout. Eligibility for the Roundup. Settlement is defined by 5 distinct groups, each reflecting the broad reach of glyphosate use across American life. Farmers who applied Roundup or similar weed killers in their fields before February 17, 2026 are included, as are landscapers, groundskeepers, and commercial gardeners who handled these products in parks, golf courses, or roadside maintenance. Home gardeners who used Roundup on their lawns or gardens before the cutoff date also qualify, even if their exposure was limited to residential settings. Individuals diagnosed with non-Hodgkin lymphoma after documented exposure, regardless of whether they worked in agriculture or simply used the product at home, are covered, as are families who lost loved ones to non-Hodgkin lymphoma linked to glyphosate. There is also a provision for people who can prove exposure before the deadline, but have not yet received a diagnosis, recognizing the long latency of the disease. The settlement applies nationwide, but only to those whose exposure or diagnosis occurred on or before February 17, 2026. This date is the hard boundary. Any use or diagnosis after that point falls outside the class. For thousands, the window to be counted is open, but will not stay open long. Compensation from the Roundup settlement is determined by a tiered matrix designed to reflect the severity of illness, age at diagnosis, and level of documented exposure. Tier 1 covers those diagnosed with aggressive non-Hodgkin lymphoma before age 30, with payouts ranging from $150,000 to $165,000. Tier 2 awards between $90,000 and $150,000 for claimants diagnosed between ages 31 and 55, regardless of non-Hodgkin lymphoma subtype. Tier 3 applies to those diagnosed after age 55, with awards from $60,000 to $90,000. Tier 4 is for individuals who can prove significant glyphosate exposure but have not yet received a diagnosis, qualifying for $6,000 to $30,000. Tier 5 supports families of deceased victims, with compensation from $30,000 to $120,000. The settlement imposes no cap per household, but each person receives only one payment, the highest they qualify for. Real-world examples put these numbers in context. John Miller, a Georgia farmer diagnosed with diffuse large B-cell lymphoma at 29, stands to receive $160,000 under Tier 1. Maria Hernandez, a municipal groundskeeper in Phoenix diagnosed at 52, is eligible for a $95,000 payout in Tier 2. Linda Thomas, who whose husband died after 3 decades of glyphosate exposure, can claim between $30,000 and $120,000 for her family under Tier 5. Early filers may receive a bonus of up to $5,000, adding urgency for those assembling documentation. Each case underscores how the payout structure aims to match compensation to the realities of exposure, illness, and loss. Glyphosate, the active ingredient in Roundup, stands at the center of a scientific and legal firestorm. In 2015, the International Agency for Research on Cancer classified glyphosate as Group 2A, probably carcinogenic to humans. This designation was based on evidence from both animal experiments and human epidemiological studies. The most influential cohort, the Agricultural Health Study, tracked more than 90,000 U.S. farm workers over decades. Its findings were clear. Those with the highest exposure faced a 23% greater risk of developing non-Hodgkin lymphoma compared to non-users. A 2023 meta-analysis reinforced this link, reporting a 31% increased odds for high-exposure groups. What makes glyphosate particularly insidious is its latency. The disease often appears 10 to 20 years after first exposure, a delay that has complicated both diagnosis and legal accountability. Mechanistic studies suggest that glyphosate can damage DNA and trigger oxidative stress, biological pathways that plausibly lead to lymphoma. Internal Monsanto documents released during litigation reveal that by 2005, company scientists had identified these very mechanisms. Memos from 2011 discuss strategies to downplay emerging concerns in regulatory filings. These records became central evidence in court, fueling the argument that Monsanto not only knew of the risks, but worked to suppress unfavorable research. The convergence of independent studies, long latency periods, and corporate memos has forged a credible chain of causation, one now recognized in both scientific and legal arenas. Pressure on Bayer reached a breaking point in March 2025, when a federal jury in Georgia handed down $2.1 billion in damages to a group of wheat and soybean farmers. Their case rested on years of pesticide application logs, medical records confirming non-Hodgkin lymphoma, and internal Monsanto documents showing the company's awareness of potential risks. This single judgment was among the largest product liability awards in U.S. history, and it sent shockwaves through the agricultural and legal worlds. Within months, similar cases began to flood courts across the country. By early 2026, more than 65,000 Roundup-related lawsuits were pending in state and federal dockets, representing farmers, landscapers, city workers, and home gardeners. Plaintiffs' lawyers, emboldened by the Georgia outcome, pressed for even larger damages, while Bayer's legal team warned of runaway liability that could threaten the company's survival. The scale and speed of these verdicts transformed the glyphosate debate from a scientific controversy into an existential financial threat. Facing the risk of more multi-billion-dollar losses, Bayer executives entered urgent negotiations with plaintiffs' committees, ultimately agreeing to the $7.25 billion settlement now before the court. For thousands of claimants, the legal tide had finally turned, but the window for action was closing fast. The path to compensation begins with a strict checklist and 2 non-negotiable deadlines. Anyone who believes they qualify must decide by June 4th, 2026, whether to stay in the class or opt out and pursue a separate lawsuit. This is the cutoff for objections as well. Miss it, and you are bound by the settlement terms. The official claims portal, weedkillerclass.com, is the only authorized site for filing. Claimants will log in, create a secure account, and upload supporting documents, purchase receipts, application logs, employment records, and medical reports if diagnosed. For families of deceased victims, death certificates and proof of relationship are required. Each document must be labeled and scanned clearly. Incomplete files will delay review or risk denial. The portal guides users through a step-by-step questionnaire, matching their evidence to one of 5 payout tiers. Early filers may receive a bonus, but only if all paperwork is submitted before the portal's first round closure. The final court approval hearing is set for July 9th, 2026. After that, the trust begins processing payments, with most awards expected within the first year. For anyone exposed to Roundup before February 17th, 2026, these are the only dates that matter. Missing them could mean losing the chance for any compensation. A single court decision now hangs over the entire Roundup settlement, a decision that could slam the door on future lawsuits or blow it wide open. The Supreme Court will rule by June 2026 on whether federal pesticide law preempts state claims against Bayer for Roundup's alleged cancer risks. The case, Bayer AG versus United States, number 22-1004, asks whether the Federal Insecticide, Fungicide, and Rodenticide Act gives the EPA sole authority to regulate glyphosate safety, blocking state-level suits over cancer warnings. Plaintiffs and a coalition of state attorneys general argue that FIFRA was never meant to erase state protections for consumers harmed by dangerous products. The stakes could not be higher. If the court sides with Bayer, the $7.25 billion settlement will become the exclusive remedy for anyone harmed by Roundup. No future state lawsuits, no additional jury awards, just the payout tiers set by the trust. The settlement contains a termination clause, so if the Supreme Court rules in Bayer's favor before July 9th, the fund is locked in and payments begin soon after. But if the court rejects preemption, state courts could see a new wave of litigation, risking rapid depletion of the trust and years of uncertainty for claimants. Legal experts warn that waiting for the Supreme Court decision is a gamble. The opt-out deadline, June 4th, 2026, will arrive weeks before the court's ruling. Anyone who misses that window is bound by the settlement forever, even if the legal landscape shifts overnight. Payments are scheduled to begin after final court approval on July 9th, but only for those who meet the deadlines. For thousands of farmers, landscapers, and families, this may be the last, and only, chance to secure compensation for years of exposure and loss. Today, the largest agricultural settlement in U.S. history stands as both compensation and warning. As Bayer faces a Supreme Court battle that could end future claims, the window for justice narrows. For thousands exposed, what happens next determines whether accountability remains a legal right or a fleeting opportunity. Share your thoughts below